I have with me over here Gaurav Mashruwala, who's here to tell us about what is a will and why is it so important. Gaurav, hi, welcome to the show. And let's start by the very basics. What is a will and why is it so important for all of us?
So first is Sakshi and Kaza, thank you so much for inviting me and giving me this opportunity. Since the question is basic, I'll keep my reply to basic instead of using the jargons. What is a will? In a very simple language, it's a document or it's a sheet of paper on which an individual who's the owner of assets or who has built assets over her entire lifetime decides and lets it know to the near and dear ones that how all those assets, the ownership, should go on to the next generation, spouse, and anybody else that he or she wants to. So, will, sometimes I jokingly call it as a financial autobiography of an individual. Now, why is it important? Because then distribution is easier. Most of the time when we find those legal disputes or when we hear about it, there is either an absence of will or even if the document is there, the clarity is not there. Okay. So, if it's there, then the near and dear ones are able to distribute it easily. The distribution aspect of all the assets is much more smoother because at least the thought process is clear. And obviously there would be some regulatory and legal requirement, but that anyway everybody has to follow. But the first part, which is the biggest and difficult part, is solved. So where there is a will, there is a family, and that will be taken care of.
So, one misconception that many people have is that only the rich needs a will. The middle class, others don't need a will. Is that true?
Well, I keep telling people the day you opened your first savings bank account, you should have a will. So it's not that only the wealthy or the middle class, and again, who's wealthy, who's middle class, that's again specific to each individual and each family. But it's not true because anybody who has assets has to deal with this question that upon his or her death, who in the family or in his close circles will go on to own that particular piece of assets.
And all assets.
And all
financial,
the assets.
Could be real assets.
Yes, yes. So it could be financial assets, it could be real estate, it could be jewelry. In fact, in will we also write nowadays known and unknown assets, because there could be few things which they are going to receive or they could be shared. And now we have also started including a point saying digital assets and username and password, but I guess that we'll discuss some other time in detail. But everything has to be narrated because who will receive those assets, who would be the eventual owner. So it's very, very important to have that, and it doesn't matter whether you consider yourself wealthy or not. And if by writing a will, if you're getting that big high that I'm wealthy, just get that, that's free for you.
What about financial assets? There are second holders, there are third holders, and you also have something called as a nomination. We've known the mutual funds industry ran a campaign on the importance of nomination. So if you have a nomination in place, if you have a second holder in place, do you still require a will?
What happens if both the first and second holder die together? If there is a car accident, or if there are any eventualities, if there is a natural calamity, then we will still need a nomination. So it can't be a situation whereby we are saying that just because I have a second applicant, there is no need for will. Please make a will, because there could be situations where both the applicants have passed away together. As far as financial assets are concerned, under normal circumstances, if there is a death of only one person, then the second person automatically becomes the owner. However, this is not true as far as real estate is concerned. So people be aware, if there is a real estate property, say there is a flat which is jointly owned by husband and wife, then upon husband's death, it's not necessary that wife will get the complete share. What will happen is, if husband has not made the will in favor of wife, then his share, and if he has a son, then his share will get equally distributed between his wife and his son. So that's one part. As far as nomination is concerned, nomination or a nominee, and again I'll use a simple language and then I'll explain, has a right to receive, not right to own. So nominee will act as a trustee, receive the asset, and the distribution will happen as per will. So nominee does not become automatically a owner. Nominee just receives on behalf of the all the benefits.
So what you're saying is that the will supersedes your second holder.
Will is eventually the final decision.
The final
yes.
decider. And any other, you spoke about the complications that could arise if you don't have a will and if you want to distribute a real estate. But any other complications that you can share with us as to what happens if you don't have a will and
in the absence of
will?
What happens is that in the absence of will, law takes over. Now there is Indian Succession Act, or there could be Hindu law or Mohammedan law, and it varies. And then the distribution will happen as per that particular act. So then the individual, the deceased person does not have any control as to how that will happen. It will happen as per law. So then the situation could be that you may not want to give up as part of the asset to a particular individual in the family for whatever reason. Either the person is doing well, or while you are alive, you have supported that son or daughter, and hence you want to give it to somebody else. Those control will not remain with you. If you have a spouse, you may want to pass on the entire control to your spouse and not give it to your children. So as long as she is alive, she can use that. Those things will not happen. So absence of will is where law takes over, and then there could be repercussions that comes in.
Okay, so there could be repercussions, yes. And last thing, Gaurav, there was a talk about inheritance tax being introduced a couple of years ago. Of course, that didn't happen. But just a thought: if there is an inheritance tax, does the presence of will or an absence of will make any difference?
Well, does the presence or absence of will make any difference? First of all, I'm not too sure whether the inheritance tax is going to come back or not. We had many decades ago. In between, there were rumors, but I believe they were only rumors, and I don't think there is anything which has actually taken place. However, if that was to take place, the beneficiaries have to pay certain amount of tax before owning it up, before the title transfers to them. Now, if there is a will, not that they will be able to avoid the inheritance tax, but what will happen is there will be a clear-cut demarcation for all the assets. And to that extent, if there is a shortage of fund to pay taxes, they know who is the beneficiary and that person has to cough it up or pay, whatever is the better word, and they probably can pool in money and pay. Otherwise, court will not allow the transfer of the titles to the beneficiary. So to that extent, will really help.
Thank you very much, Gaurav, for highlighting the importance of why we need a will.